This credibility has a number of meanings
yes.
in English. And so you can have credibility as meaning you're telling lies or you're truthful. You can have credibility because you happen to put a whole claim together or something, and that's seen as credible. You can have credible options because one's better than the other. So it's very difficult. And this is, we checked, most European languages have the same thing. They have different issues. You'll be pleased to know, except Hungarian. The Hungarian language is evidently so unique that you would know the difference between it. Anyway, so that's the problem. And I love these two words. Ridiculously complex. Contextual disambiguation is the correct term you have to apply to see which version of the word you are using. And by pure coincidence, my brother-in-law is a lexicologist. He writes dictionaries and is an authority on dictionary writing. And even though he's a New Zealander, he was one of the team that wrote the latest version of the German dictionary in Mannheim for 20 years. He's been there, and he was RS&T. Anyway, he's also the world authority on Grimm brothers and Grimm's fairy tales and so forth. Anyway, interesting family I married into. But he told me that's the term. In other words, you've got to work out what's the right meaning for the right context that you've got it in. Okay, so this is just two of the meanings of credibility. You don't look at the credibility of, this is a credible claim. You can say that in layman's language, but frankly, to get the right answers in an assessment of a refugee case, it should always be just this: the credibility of the past and present evidence of the claimant, and I suppose I should add to that, and other supporting, other supporting evidence they may bring. Only the latter is valid. If you use the first, you'll get yourself into confusion, and you'll be deciding risk areas in the middle of credibility, and you'll be getting confused between harm and the reason for having the structure is so you can see each element. We started, you remember, with the 1A2, and I had the coloured parts over the different wording within it. And so this makes it a lot easier to do. It doesn't mean to say that very bright people can actually have the whole lot in their head at once and still get the right answer. As I said before, all this structure or step-by-step approaches, it gives you it does it step-by-step in a structure that if you follow it, your likelihood of getting it wrong or getting it right is so much higher. That's really what we concluded. Okay, an interesting digression. So in Japanese, you can have several meanings as well, can you? Of credibility. I don't know. Is the word used in different, has it different meanings is probably the same. It does it? But would there be a separate word for talking about what we'd say the credibility of a whole claim as opposed to just the credibility of a claimant? I think it's just an interesting point that when you start using language in other languages, we can just see the problems it causes. And
I think sometimes also the bit tricky things when I was participating in some conference in Vienna regarding a commercial law conference, and some French delegation said in French no such word for the proper interpretation of the fairness. Fairness is a really English concept. Fairness, yes, you know. Yep. Maybe some kind of party autonomies for the kind of a natural justice or due process. maybe the French word is équité, but this is not the same as fairness, something like that. In Japanese, 公正さ or something that, so I realized that even the French and English, it's not so easy to translate to each other. So, because of some kind of a way of thinking of the...
It is, yes, you're right, and different philosophical backgrounds to such words. But there's nothing more delightful, and perhaps our European, our Swiss friend will know. There's nothing more delightful than seeing people, than English and French speakers, debating what is the correct words for things.
Yeah. Maybe this Geneva Convention.
Exactly,
really
and because there are two official versions.
Two original.
Yep,
yes,
in French. So and that's why there was so much argument, or has been, I talked about non-refoulement. So in the English, because English is like Japanese, it's a language that absorbs other words. English said, we'll use the French word and save the argument. And so that happens all the time. So it's all these things come into it. Okay, we'll go on from there rather than have a 2-hour debate on on differences. Okay, so the resolution that came out of the big meeting we had in Madrid was this one here, that international judicial basic criteria and standards of good practice used in credibility assessment. This is what it is. Standards of good practice suggested for sound reasoning that supports valid findings under the criteria have been developed by international refugee law judges. They cover a wide range of issues that are applicable in credibility assessment, while appropriate deference to the skill and experience should always be given to first instance decision makers, because they have the hardest job in many ways, because they're getting the raw material. They're not getting it 2 steps up the track or 1 step up the track when it's been filtered out and the person's had a chance to tell their story 2 or 3 times. So, or full merits review judges. You know what a full merits review is? What do you think it is? It's the situation that prevails in a lot of, particularly common law countries, but in other countries, where a first instance, there's an appeal from a first instance decision maker, usually a government official. It will go to a tribunal or often to a court, and probably the best, says he from that experience, but probably the best way of, and the fairest way, again, to use that word, of handling the appeal, and because of the declaratory nature we spoke about, is to do a full merits review. In other words, completely hear the whole case again, as at the later time, maybe months later, and you can take into account what is said in the first decision of the first instance decision maker, but it's not binding on anybody. So you can start, so the appellant has the opportunity to start again with a complete fresh sheet, and he is then examined, can be cross-examination, the whole lot, usually done not in the usual adversarial manner, you know, the one side leaving the court in the middle. The danger in this jurisdiction to do that is that if you have a more adversarial style, one or other side may never ask the right questions. So the judge would be in the situation where if they ask the right questions, they might get the real answer I want. So in most jurisdictions, particularly again common law jurisdictions, because the issues are so serious, it's what's called, if there is a protection point arising, the judge can, so-called, is what's called enter the arena and take an investigating approach and ask questions, all right? In the New Zealand system, the judges do most of the questioning with an opportunity at the end for either side to put their view forward. In the British one, it's more if you see a protection point, then you can intervene. It's called a Robinson obvious point. Does that mean anything to you? No, it just so happens that the case of Robinson is the precedent for it, where that was first decided. Okay, we'll go on. So, some other preliminary assumptions. It's an onerous task. We've been talking that, both at first instance and on appeal. You've got national transposing law. That should be, it's Geneva Convention, a mistake made by me, sorry, it should be CSR. In other words, the laws that bring it into account, as we said, allow a country to set their own procedures, not the law, but you must go through the correct procedures that your own state puts in it for doing it. Then you've got other protection instruments that may impact on it, such as the CAT, other international human rights conventions, and judicial interpretations, both domestically and internationally, that may be relevant to the case. The guidance is based on what's so-called international administrative law norms. In other words, how do you go about determining the cases between an individual and the state fairly and justly? Again, it's more customary international law, and it also falls back to the reality of the Vienna Convention on the Law of Treaties we spoke about yesterday, and the requirement to fairly interpret it. Pacta servanda, okay? And so the issues are so serious, you know, life and death, serious persecution as a possibility, that only the highest standards, or very high, maybe rather than highest, the very high standards of fairness are applicable. All right? So that's again why you have to treat these cases very fairly, because the consequences are horrific in many situations. All right? And your credibility assessment is thus a tool that we use to establish a claimant's accepted profile or characteristics that I spoke about before. In other words, it's what the assessing officer or the court decides I can accept. It doesn't really mean this is absolutely true or that's not absolutely true. It means what I'm prepared to accept when I look at all the evidence this person has given me, in its totality, what is the profile of this person. In other words, this is an Iranian woman, aged in her 30s, who had problems from the police force or one of the other religious police, because she and her friends had makeup on and walked around the streets looking very glamorous and so forth, coming from North Tehran, and therefore were picked on and would continue to be so because that is their lifestyle that they shouldn't have to change. So that's what, and you say, right, when that person, objectively, person with that profile goes back to Tehran, what is the likelihood of such a person being persecuted? And you can look up the country information and see what might happen to such a person. And I had a group of young ladies from Iran that came before us at one stage who also had, because they thought it was glamorous, gone to Christian church ceremonies and so forth as well, because in the church they're allowed to take their headdress off and have their beautiful hair and their makeup on and all the rest of it, and they liked that so much that they would go dressed up like that. So you can see a person with such a profile going back to Tehran or to Iran, are they going to be at risk of being persecuted? Oh, recognising that they get picked up on the street and put in some fairly nasty white vans and taken to particularly religious police, which are far more belligerent in their attacks and made to sit on the ground, and likelihood of rape and all sorts of other things going on. So, do you think they're at risk of being persecuted when they're returned? Well, like real chance of being persecuted? You do, yeah. Because that package convinces you, does it?
Yes.
Yeah. Well, that's the job you have to. I'm not saying whether others are right or wrong, but I'm just saying that's the job you have to do when you put all that package of information I've just told you in together, and then having got the profile, you can then go on to look at, which we'll do in a minute, the harm that would happen to them, how serious is it, and then the risk. How likely is the risk? All right? Okay. The guidance principle there, they're not exhaustive and they overlap. Okay. So the consensus, these are the main areas they fall into, recognising that they all overlap to a degree, but in a sort of priority list of credibility points, if you are wanting to be right or wrong, impossibility is, or near impossibility is obviously the first one. When somebody gives you a story that they jumped across the border between Ghana and Nigeria and then walked 300 miles to go back, but you look on the map and see they don't actually abut each other. They're not joined together. There's not a common border. So you might explore that for a while, and then after a while the story does not hang together. Other cases we've had like that where you may have a woman telling a story for a long period of time, and when you go through it on several times, it still turns up she had a baby when she was 4 months pregnant. It just is an impossibility. I'm giving you some fairly ridiculous examples, but that's the sort of thing that is obviously the highest level of incredibility you can get to. Again, the next one really is external and internal consistency. External is when country information tells you that's not the situation or it is the situation. So you can go through consistency with that sort of thing. Internal is their own story, like the person saying they crossed a border that doesn't exist or that sort of thing. Then it gets harder. Plausibility. Pretty hard, pretty word in English that gives you some concerns. Is it plausible? And you can see, as you come down, these three here, it's more and more subjective to the brain of the assessor rather than scientifically based. But plausibility is still part of, provided your reasoning is solid, and it strongly will hold together that this is an utterly implausible. But you also, if you're going to do plausibility for good reasoning, you should always test the opposite view, if you know what I mean. You just look at it and say, well, yes, I think it's implausible, but let me look at the country information. Let me ask questions, always, to hear the other side, from the claimant or the appellant before you. So often the best way of doing that is to have an interview with them for maybe several hours, and then you may take a break, coffee break or something, and then go down and go through all the things that might concern you, then go back into the room and say, look, there are these 4 or 5 matters that concern me in your evidence, and I'd like you to comment on them. You don't have to rush, just go through them, and if you want to talk to your counsel or something, do so. But then they have the opportunity to come back to you and explain why they were saying it, those things. And I've talked about this before. The assessment should not be made on each individual item. It should be made on what are called material issues in the round. With all of the things put together, then make your decision, like our friend was just doing before. He was picking up all the pieces of evidence I was sort of throwing out and making a decision on the totality of it. Is there sufficiency or insufficiency of detail to make an assessment? Sometimes you will get cases where there'll be evidence, all right, but it's very scant. In other words, very light on detail. And you may think, well, that's, yes, that looks credible of that, but when you dig into the detail, you find after a lot of digging that you really can't get to the substance of any story at all. And so in such cases, you need to go through it more carefully and ensure it's not what we call a learned story that they may have had packaged for them when they were transported by a people smuggler or somebody else, some friend told them the story. You have to be cautious of that, doing it fairly, but it does happen. And so you just need to just explore further into it and see it's not a learned story. The timeliness of the claim is important. You know, why have you been here for 3 years and you've never made a claim? Is a valid question and valid point of credibility concern. However, it may be, discussing yesterday, there's been a change of government, or the dictator has been overthrown, peace has broken out, or whatever it might be, or the opposite, more likely. So things have got far worse, and the party that I supported for 20 years is out of power. And because I was a prominent leader, or even just a rank and file member, I am now at a risk, and so therefore I'm claiming refugee status. Totally valid, good reason for not having the claim. Other ones, people who just don't have the intelligence or learning to know what refugee status even might be. And it's only after they've been in the country which they ran away to, got here, don't speak the language, been here for some years working legally or illegally, and then suddenly they find out that they could claim status. And it gets, again, more concerning if they are picked up and because for immigration reasons, and they're saying they're going to be deported. So they then make a claim. That is not to say their claim was not a valid one, purely because of that. They must have the opportunity to explain the whole situation. It could well be that they have a totally valid claim. It could be that they are making that claim to buy time, which means two things. The state should have an efficient system of dealing with those cases, which can be done, and is done if you have good, sound refugee law and systems in place, and not a backlog that's 5 years before that person comes up to be assessed, because all that is doing is encouraging abuse. So the system itself needs to be managerially and realistically efficient, at the same time as being fair and meeting all the things I've been going through. It's not hard. It's not easy. It's difficult. But unless you achieve that, the very system you've got will encourage the abuse. And in countries particularly well known for getting it right and being efficient, that is where you should really use that example to use your efficiency and your best thinking fairly, promptly and so forth with trained people, and then it works. And believe it or not, the international accepted refugee law in countries, the two countries I've worked in, have improved vastly by just following the principles we're talking about and doing it well and training people well to do it and being entirely fair. All right, it may end up that 30-40% of people are granted status once you've got the system working efficiently. When it wasn't, it might have been 3%, or not that low, but let's say 10%. But once you get the abuse out of the system, then the system operates much better, everybody's much happier, it costs a lot less, and so the taxpayers will love you for it. That's, you've got to, it's about all pieces. It's not just about, we don't like these people coming into our country, but we're not going to do much about curing it, or we're going to give them poor service, poorly trained people to do the job, you're just asking for the abuse. Anyway, I won't go on. This is a personal involvement that's often tied into this one here, where you go through the story and that sounds very nice, but again, it's taking somebody else's story and using it as the basis for another claim. So caution has to be... Right, that's the next one. Okay, so we're going to go through quickly well, not quickly because there's a lot of them. It's about 45 reasons, I think. They're grouped, again, the colours are just used to break them up in there. Substantive standards, procedural standards, and we'll talk about vulnerable claimants, and the so-called residual or benefit of the doubt principles. Now, there's a full list. If you look in the structured paper, this is what we spent a lot of time pulling together, and under each one, I think if you go to, where is it? Yep. Part 3 of this paper, we're not going to go through the whole lot now, but they're all set out in some detail, starting with the basic criteria we've just been discussing, and then going into each item, one after the other. So, treatment of substantive evidence, for example. I think the number of them come up now. We go to the next one. And these are the sort of things that you've got to be looking for. Consistency. Claims should be presented by claimants in an internally and externally consistent manner. All right? If they're not, you have cause for debate. So the effect on credibility of material inconsistency or discrepancy must be clearly explained to claimants, and they must be given the chance to respond. That was the fairness we're talking about. The response given by the claimant should be taken into account. Real consideration should be given to whether the explanation does, in fact, resolve the concern. Decision makers must discipline themselves not to take a position about an opening inconsistency. Often, again, translation is the cause of it, not reality. Give the chance to explain and be prepared to abandon a previous view without prejudice to the claimant. So then the next one I've talked about several times. This is the famous Latin phrase used for it, audi alteram partem, which just means hear the other side. And the other side must be heard. Potentially negative material must be put, in other words, I was talking about it a moment ago, put to them for comment.
Maybe a bit will explain this equality of arms. Maybe this is specifically the common law jurisdictions.
No, it comes
the
from,
same as
it's right across
natural justice, or
right across Europe. It's a Latin. It's a Roman-based law.
Yeah, Latin. Yeah, I know.
Yeah,
but
so
this equality of arms is also referred as a natural justice or a due process of the common law.
It's part of
Yeah.
your due process. Yes.
That is, anyone have to have a right to answer. If you attacked, you have a kind of a opportunity defense, so proper defense for the. In most cases, criminal justice is sometimes.
It's used in criminal justice, and but it's very much part of accepted international law, and it's very much part of civil law, or European versions of it anyway. Because that's where it comes from. It comes from the Holy Roman Empire and laws there and so forth over the years. Now, the next one, of course, is that reasons must be given conclusively. In other words, if you're going through and making a credibility assessment which says I'm not prepared to accept this item of evidence, this material piece of evidence they've given, you must give reasons for it, and those reasons will be tied up to it's inconsistent or it's totally lacking in plausibility or what have you. in the way you're doing it. So you can't and you should not put in the reasoning, which unfortunately you tend to see a lot, when people, we call it in English, having an each way bet. In other words, the decision maker really doesn't know one way or the other. And so they use terms like may have happened. What does that mean? Does that decide whether it's credible or not credible? And frankly, the number of applications for leave to appeal to the court I was in London that used that sort of language was unbelievable. And they would be sent back to the court, probably for another judge to do it again. Very wasteful of resources. So you see it in so many decisions that this sort of may have been, or the decision maker has not made up their mind when that's their job to make up their mind and given the reasons. And if they can't, then you should accept the story. If you've got no reason to knock it down, then either you haven't conducted a good enough interview or you should give it in favour of the claimant. It's as simple as that. The next one is a good one, materiality. Too often, rejections of credibility are based on matters that are immaterial to the true risk factors involved and the characteristics of the claimant and the risks on return. Does it matter that they've said once they were born and they're 22 years old, but somewhere else they said they were 18 or something or other? Does that change the risk? What's material about that to the person's... and that happens, sadly, usually at first instance, as somebody grasping to find reasons to turn things down. And again, on appeal, it should be knocked back and saying, no, you can't. It lacks materiality. It doesn't get to the core. So there's a beautiful phrase in an old English case which says, pedantic insistence on mindless trivia is not the approach. And so don't get lost in silly detail. Okay. Always take an objective approach, checking it against COI, against country information, checking it against good evidence that may have come out, giving it against experts' evidence that might be in cases, for example, that they have in the UK called country guidance cases, which are not binding, but may give you a very good overview of what's going on in that country when a sample case has been taken and lots and lots of evidence given, and so you get the situation where a sort of profile of risk comes together in those cases. So use those. It may be a British case or it may be a French case or a German one, but no reason why you shouldn't use it to find out more information. You've got to, if you need to, put it to the claimants, but there is a lot of international information out there, either in publications by reputable organisation like our Austrian friends not here, but there's Accord, which is the name of a very, very good, probably in my view one of the best COI gatherers in the world. The British have very fair systems from the old Home Office that does it, run by an independent board. The Americans have the Department of State reports, which you need to be a bit careful with because they tend to take somewhat of a bias along the lines Sato Sensei was talking about before. But others, Human Rights Watch is usually very good. UNHCR reports, very good. So all these things will give guidance on country information. Amnesty International, usually fairly good too, although you would think partially biased. But again, you must be careful to use objective information.
Regarding a COI database, my center, Research Center for Sustainable Peace, so has a project of CDR. This homepage provide for some database about COI. Just we got some assistance from the LexisNexis, some database companies, and but unfortunately the funding was now short, so no longer updating. But until maybe 2 years ago, and updated this also. If you like, you can just check our homepage. Maybe Sujin will give you to this database. This is also open to the public. So I think such a COI database is also created in Australia, Red Cross.
Yes,
yeah,
the Red Cross,
nice.
the International Crisis Centre. That's very good stuff. In fact, the case study we'll look at has got material from them.
If I may add, we have a source from the UNCR called Refugee,
Yeah,
or we
sorry.
have
Yeah.
and also ECOINet.
Mm.
That's where I used to
RefWorld.
visit all those COI.
Yep, yeah. So no, RefWorld is almost an essential. And if you can build up your own library or use one of these ones, particularly in your own language. But again, I have to say, unfortunately, or reality is that 90% of the COI is in English. And so, like it or not, it's the lingua franca, and it's the most common language, so that's where you find it. So you've got to get the translation done. You want to make any comment on your job of trying to set up a COI centre? That's very good that that's growing in Japan and it's used.
Yeah, anyway, there's a CDR, Center of Documentation of Refugee and Migrant. The database available in Japanese. And we just collected some information from the public newspapers and also journals and these sort of things. Also identify the source of this information. But we had a problem one day because of copyright issues. Unfortunately, Japanese law for copyright is not so friendly for even academic research. Some newspapers demand some patent, some royalty, something like that. But we negotiated. Actually, I think some journal. No. So correspondence of the what's this? Not Reuters, another one. API. So this is also a kind of a special arrangement for the University of Tokyo. So I think University of Tokyo students, professors use this data without any special extra payment, something like that. So maybe we will coordinate or network for these things, and hopefully the MOJ will just have a kind of such a center for access.
It's good.
That is a good idea.
Yeah, no, I think that's excellent, and I would encourage you, both you and the CDR, to work in cooperation with some of the well-known international ones, like as I was talking about, Accord, or there's a German one called Milo, or RefWorld, and because the more you put it together with other ones, the better it will get, and you get balance in it, because you don't want COI that's prepared just to turn people down. You've got to see both sides and get the explanations as correct as possible, not just in one direction or another. It's right, we're just giving favourable comments about Austria as you walked in. So. Okay, and there are problems often I talked about before, people borrowing other people's claims. So each case, it's not an excuse to turn it down, because it's a similar story you've heard many, many times before. Each case has got to be treated on its merit. It gives rise to caution, but don't just jump to conclusions. One shouldn't. and if you're acting for such people, by all means you should go through the checking to see whether they have just, it's another story they've learned, or it is one that's just somebody else's story and not their own. Corroboration, as I said, is not needed and can be dangerous, although if it is credible, then use it, but realise caution in the use of it if you're an advocate. Partially credible claims, that can happen. Some people will tell partly the truth and partly glamorise the story with other. And in fact, the case study we're going to look at might have that included in it. But the main thing is that when you get to the end of all that, I may have mentioned it yesterday, you can have people, like I was saying, Eritrean woman of a certain age, that's all they have to prove, then they're a refugee. So, and that used to happen with a lot of Somali cases some years ago, that virtually all you had to prove was that you were Somali and didn't come from one of the main clans, and you're an Ashraf or something like that, and that wasn't that difficult to obtain, so it have markings and various things that you can tell physically from them as well as anything else, and so they would then become a refugee. So it's, and they may, the whole lot, the rest of it may be absolute rubbish, and so that's, you know, it doesn't mean to say they're not at a real risk of being persecuted. Surplus claims, in other words, claims put in after the person has been in the country for perhaps some time. Often there is earlier lies or something in those that are proven. And the very difficult subject of whether the case is put forward in good faith or bad faith. And we may have time to look at that later on. There's some quite, New Zealand happens to have some of the leading cases on that, where an advocate, not a lawyer, made up a story for his client and got the TV news people to come to his house and put it all over the news, which was just a pack of lies in the end, and presented that as a case. And in the end it turned out that the whole thing was being put up by this advocate, this representative. And so this person then had clearly presented it in bad faith, but once we dug through all that, it turned out the person could still be a refugee because the actual story was one that had been contrived by his advocate. So there are dangerous things like that. In other words, somebody's done it on your behalf. Another one where sadly a group of bishops and ministers, religious ministers in New Zealand, involved in a guy who was on a hunger strike, and they were protesting outside and saying all terrible things, got huge publicity. And in the end, when finally the guy fortunately didn't want to be force-fed and gave up on his hunger strike, his case went ahead, and I actually sat on it, and it turned out that his whole story was a fabrication, and the ministers had put themselves and been utterly and totally duped. In other words, they'd been conned, if you understand, confidence trick almost on them by this guy. So he definitely wasn't a refugee, but the whole thing, the good faith, bad faith of it, becomes very difficult. We won't go much further. The basic rule is even if they're given in bad faith, the UNHCR approach is that you should still give them status. A lot of states have problems with that, including New Zealand. Funnily enough, less so in UK. They seem, their law is more, doesn't matter whether it was bad faith or good faith, they will still allow it. Okay, and then caution, big caution over demeanour. We spoke about that before. Again, you have to use extreme caution because different people have different approaches. If you're dealing, for example, a simple example with Polynesian people, they will, because you're a figure of of respect, they will look down like this and talk, and they won't give their answers to you, and you won't actually, they talk in a quiet voice because it's all a mark of respect, but you don't know what's going on. And so you can't say, oh, they never looked me in the face, they don't have a, and that sort of thing, they never gave me eye contact. Totally wrong. It's a matter of, so you, and lots of races have, and lots of groups of people have such tendencies, so it's very dangerous to rely on demeanour. But it still needs a bit of balance, because what's the reality? We always try to have a face-to-face hearing. Personal interview is really an essential part of it. People can fairly present their case. So oral hearings or oral discussion is an essential part of it. And there's a Japanese saying, I think, I can't remember it, but it's Hayokan Nikken or something or other, 100 viewings, 100 words are not worth one viewing. And it's a very good Japanese phrase. So it's face-to-face works. So, and therefore countries that go too far down what we call papers case, just present the papers back and forth, are in very dangerous territory. And our Swiss friend, Switzerland has used a papers review system which has been highly criticised for that reason, because they never actually talk to the people at the appeal levels. And so they've had it, I don't know if they've still got it. Do they think they still have it? I don't think they do. I think there's still papers case appeals there, which is very difficult to do. Okay. Yes. No, it's not. You've got to be very careful in using it. In this particular field, be careful using it, because it's not like a domestic case. Well, none of refugee law is like a domestic, but you can't, for example, call the witness or subpoena them to come before you and examine them, and that sort of thing. So corroboration is a dangerous thing for an advocate and a dangerous thing for a decision maker to rely on, because if you force, if you say, right, you've got to give corroborative evidence of what you do and get evidence, you're never going to get evidence from the government if their fear is the government, or if you are, you can guarantee it will be against them. So those sorts of things make it dangerous. So you have to there look at the totality of all the other evidence, and you can almost have cases where, putting it simply, less is more. The case is more believable when they've got no information, or they've got nothing that's sort of a nice signed document with a seal on it and all the rest of it, than they have the other way around, because so much of it is fabricated around the world. And their families, often with the best intentions in the world, will send them fabricated documents, because they go along and a poorly trained advocate or lawyer for them will say, oh, well, give me some evidence, I've got to get some, I've got to put it forward, otherwise the assessors won't accept it. Dangerous, because their parents or somebody will go along and try and get one. I spoke before, you used to be able to buy them quite cheaply outside a Bangladeshi court if you wanted to prove you were being tried in Bangladesh. And all that happened was you just paid them some money, and the actual clerk of the judge, and occasionally the actual judge, would, for a certain amount of money, bakshi, they would manufacture the thing for you, and it had lovely seals and stamps all over it. Totally worthless, dangerous, because then the person's at far more risk of being declined on credibility than they were if they just told their story. So that's why it's not that in the civil and criminal context you can see again why refugee law is different, because yes, you can get people in and you can get the level of confidence so much higher than you can in refugee law. It is just different. You missed this before. We just went through about 12 points. It's all right. They're in the papers. You can see it afterwards. Okay, so there are a lot of procedural ones too that cause problems, and through faulty, inappropriate procedures, to present their claim fairly, reasonably, in both written and oral form. So we've talked a lot about interpreters, all right? Basically, the law, I think, in most countries is you can only really refuse an interpreter if there is bias, clear bias, or incompetence. The incompetence one will usually come out very quickly when they'll put their hand up, I'm not, not saying that, and all those sorts of things. And poor representation or legal support. I gave a good example of that a moment, where the guy manufactured a story for this fellow. Time limits. I know you did have a 60-day time limit here. You can't just put time limits on things like that. It isn't. The risk of persecution doesn't go away in 60 days. It just doesn't fit. Anyway, in appeals, getting translations done. Again, bias, incompetence, conflict of interest by the decision makers or the system itself. It's the law, the phrase you've probably seen everywhere in the world, justice must be seen to be done. So it's not being seen to be done if the judge is biased or utterly incompetent, or even, sadly, as we had once or twice in the UK, where the guy fell asleep, where the judge fell asleep in the middle of the case, and in a Scottish case. Anyway, it can happen. Not a lot of confidence in the competence of the decision. Anyway, okay. Now, vulnerable claimants, important one. And I hope if you do get the chance, you will look at that video for 14 minutes. Okay, we're nearly out of time again. So there's one general standard that provided that not only will it be impossible, the list is inexhaustive, but also frequently the case of vulnerability of individual claimants may have a number of overlapping causes. So the PTSD one we spoke about yesterday, it quite often has got all sorts of other nuances, because that's what psychological and sometimes physical impairment as well as psychological got to be taken into account. So that's the vulnerability one, and just before we leave that, we'll just take the one more and then we'll finish vulnerability. Just give me one more. If you look at, and you can see it in the paper, there's a whole list of things. Children, fairly obvious, much less insistence on everything with child. Always, if you possibly can, to have an adult or an approved person. In New Zealand, you cannot come to any court without having an advocate for the child, as they call it, who represents them in everything, especially unaccompanied. Women, domestic violence, sexual abuse, forced marriage, all these things, honour killings. Used to get a lot of those sort of cases. Even within the UK, they would go to the honour killings itself. Victims of trafficking, we've talked about PSD, religious beliefs and what comes with them, sexual orientation, ethnic backgrounds, physical, the list goes on and on. All right? So we'll stop there and take a break for 10 minutes.